welcome back. Here's our next video lecture. This is for Class 16, and this is the introduction to derivative litigation. So just to clarify a little bit, we've finished completely with our discussion of fiduciary duties, and we're moving on to a new topic. So derivative litigation is something that's been with us in one way or another throughout the whole semester. It's very hard to talk about corporations issues at all without making some sort of reference to derivative litigation. But we've mostly talked about derivative litigation as if it's relatively straightforward. In principle, it is. I mean, on some abstract level, it's really very simple to understand. The idea is that in a corporation, the shareholders, even though they may not be asserting rights that belong to them completely, can bring lawsuits on behalf of the corporation. Most importantly, they can assert the corporation's fiduciary benefits, fiduciary rights, as against fiduciaries that owe those rights. So shareholders can cause the corporation to sue its own directors and officers. The courts, as a matter of equity, made this up over the period of many decades, starting quite a long time ago. And they did it because they felt a need to make way for someone to assert rights against fiduciaries when otherwise those rights, those obligations would go unenforced. In other words, the rights enforced by shareholder derivative plaintiffs, which generally speaking are fiduciary rights, are rights held by the corporation against its own fiduciaries, but it so happens that the people who ordinarily would cause the corporation to file lawsuits to protect its rights are those same fiduciaries. So the board members and the CEO and so on aren't very likely to sue themselves. They aren't very likely to cause the corporation to sue themselves. And therefore, the courts have said, well, if these rights are going to have any effect, we have to find somebody else who can enforce them, and that sort of naturally falls to shareholders who have a very clear interest in doing so in a lot of cases. Okay, well, that's the simple version, and it makes it sound relatively simple, but indeed it is not. The procedural rules surrounding derivative litigation are really complicated, and they're complicated for the following reasons. And this is sort of big picture stuff, which I offer because I think it could be helpful in understanding the detailed rules to follow. Okay, so the big picture reasons that derivative litigation gets complicated are, first of all, as the courts often say, and this isn't going to make a lot of sense at first, but I think it's helpful once you get it. As the courts often say, the reason that we have rules in derivative litigation, the policy that underlies all the rules the courts have made surrounding derivative litigation, is really the same underlying policy of the business judgment rule. Remember, the business judgment rule, which is a very fundamental policy in corporation law, says management of the firm is ultimately in the hands of the directors. Management of the firm, all decisions either must be made by the directors or in delegation from them. Management of the firm is not in the hands of shareholders, even though they ultimately own the corporation. That's why we have this business judgment rule deference under which courts are very reticent to invade or review the substantive business decisions of its managers. Remember, that same policy is contained in a very important provision of the Model Business Corporation Act, Section 8.01, which says decisions of the corporation are ultimately vested in the board. Okay, well, that same policy underlies derivative litigation because, as we're going to see, the rules of derivative litigation all at least nominally exist to make sure that the decision to file a lawsuit, which after all is a very important decision in the life of a business, is ultimately left in the hands of the board of directors, except in circumstances where they can't be trusted to make the decision for themselves. So we're going to spend a fair bit of time, for example, talking about the demand requirement. Well, we require demand because we want to give the board the opportunity to decide whether to sue its own fiduciaries. We excuse that requirement only where demand would be futile, because in those cases we think that the board really can't be trusted. In the rare cases when we think boards can't be trusted to make the right decisions, we allow derivative litigation to go forward without a demand, and so on and so forth. All right, so that's the fundamental policy idea. A second reason that this all gets kind of complicated is perhaps political, in the sense that there is the view not held by everyone, and it's not obviously right or wrong. You can feel about it how you like, but there is the view that derivative litigation is at some risk of being abused. That is, it's at some risk of being used by plaintiffs' attorneys for their own gain in ways that may not benefit corporations. And so the courts have put a bunch of hurdles in the way of, as they sometimes say, nuisance litigation or strike suits or the like. So we get a bunch of rules, and it turns out every single one of the rules that we're going to study, every single one of the rules of procedure that surrounds derivative litigation burdens the plaintiff and does not burden the corporation. That is, it will always be the corporate, I'm sorry, I kind of said that wrong. Burdens the plaintiff, but not the fiduciary defendants. So in every case, when somebody is asserting some procedural obligation of derivative litigation or claiming that a suit is derivative rather than direct, it's always going to be the fiduciary defendant claiming that, because those rules always burden the plaintiffs. Okay, so let's talk about some of these rules then and sort of introduce where we're going. So for today's lecture, we're actually only going to do two things, and there's more coming. The first thing we're going to do after we introduce the basic structure and the basic rules surrounding derivative litigation is we're going to talk about one very basic problem, which is a little harder than it sounds, and that is, how do you distinguish a derivative suit from a non-derivative suit? How do you tell when a case is derivative as opposed to, as we say, direct? The second thing we'll do is we will introduce the demand requirement and talk about some of the issues under it, and that's more than enough for one class period, because that stuff gets a little hairy. Okay, so that's what we're doing for today. Now, before we get into any of the more heavy details, let's look at the basic source of procedural obligations as they currently exist in Delaware, and that is in Delaware Chancery Rule 23.1. So the Chancery rules are just the rules of civil procedure that apply in the Delaware Chancery courts. These rules happen to be quite similar to the federal rules of civil procedure, and they're similar to the civil procedure rules that apply in most state courts. And indeed, most jurisdictions have a rule in court procedural rules that is similar to Rule 23.1 of the Delaware Chancery rules. Anyway, this thing contains some particular little procedural obligations in it, so let's take a look. Okay, now one thing to think about that's actually kind of useful is to notice that the derivative rules, the rule for derivative litigation in the Delaware Chancery rules, is in Rule 23.1, and that is not coincidentally quite similar to the number 23. You might remember from Civ Pro class that in the federal rules of civil procedure, the rule that governs class actions is Rule 23. And indeed, in the federal rules, the class action rule is 23, and then the federal derivative litigation rule is also Federal Rule 23.1. And that's not a coincidence, because class actions and derivative actions have a lot in common. One thing they have in common, and a thing that explains some of the procedures that surround this stuff, is that derivative cases tend to be representative in nature. That is, the shareholder plaintiff that brings the case is a person who seeks to assert rights that really affect lots of other people. Strictly speaking, in a derivative case, the derivative shareholder plaintiff, the named plaintiff in the case, isn't actually representing the interests of other shareholders, because that person is asserting rights that actually belong to the corporation. So strictly speaking, the only party whose rights are being asserted belong to the corporation. So it's not like a class action in that sense. However, it is representative in the sense that the derivative plaintiff is asserting legal rights that if that person, whether they're successful or not, will have consequences that affect all the other shareholders. So with that in mind, some of these rules exist to make sure that the interests of everybody involved are represented. Okay, so let's take a look at the words of this thing. First of all, it's of some interest that this rule actually applies to derivative actions involving not just corporations, but also unincorporated entities that have multiple members. It turns out that the members of lots of business entities, whether they're corporations or not, can sue on a derivative basis. So that's true in limited liability companies and limited partnerships. It can be true even in partnerships and so on. Okay, but where this gets interesting, where important obligations start to appear in this rule is a ways down in the paragraph. First of all, the plaintiff has to assert in the complaint that the plaintiff was a shareholder or member at the time of the transaction of which the plaintiff complains, or that the plaintiff's share membership thereafter devolved on the plaintiff by operation of law. Okay, so in other words, that's a standing requirement. You had to have been a shareholder at the time of the challenged conduct. In some jurisdictions, you actually have to keep your share all the way through litigation. That's true under the federal rules, for example. And the whole case can be dismissed if the plaintiff sells their shares before the case is terminated. That's not true in Delaware, for what it's worth. Next, and this is where it gets really important, the complaint shall also allege with particularity the efforts, if any, made by plaintiff to obtain the action the plaintiff desires from the directors or comparable authority, and the reasons for the plaintiff's failure to obtain the action or for not making the effort. Okay, that's really very significant. That's the demand requirement. Notice that it begins with an important word. The complaint shall allege with particularity. Okay, I think people know what this means, but let's just say out loud what it means. That means you have to say really very specifically details and dates and times and people's names and so on concerning the efforts you made to make a demand. Or if you didn't make a demand, you have to plead with particularity the fact that you did not make demand and the reasons that you didn't do it. In other words, both the making of a demand and or your claim of futility have to be pled with particularity. Okay, the next paragraph, which in your book appears on the next page, on page 663, Rule 23.1 appears in your book as well as in the slide that I'm showing you. And the remainder, this is paragraph B in the slide. The action shall not be dismissed or compromised without approval of the court. Okay, so that's an example of how derivative litigation is like class litigation. Once you file a derivative suit and you're in court, you can't just settle or dismiss your case. The court has to make a determination that it's in the best interest of the corporation. Okay, so those are some basic procedural obligations. Just to review, we basically learned 3 of them from Rule 23.1 itself. First, the plaintiff has to allege standing by asserting in the complaint that they were a shareholder at the time of the challenged conduct. Second, the plaintiff has to plead with particularity the facts surrounding the making of a demand or reasons for failure to make that. And let me point one thing out about that. I didn't say this earlier, and maybe I should have. The facts surrounding demand have to be pled with particularity, even though these are allegations to be made in the complaint itself, meaning that these facts have to be pled before the plaintiff will have had access to discovery. This point comes up a little bit in Grimes versus Donald, the second half of that opinion we read, and this is a fairly harsh little thing for plaintiffs, but as we see, the Delaware courts at least have no sympathy for that fact. The courts like to say, sure, it's rough that plaintiffs have to plead facts with particularity without access to discovery, but they must make use of the quote-unquote tools at hand. So you got to do your best with searches on the internet or publicly available information or SEC filings or whatever you personally can discover through whatever access you have to the corporation itself, which usually is none, at least in publicly traded corporations. Okay, but anyway, the second rule contained within 23.1 itself is the pleading of demand, and the final one is that derivative cases can't be settled without the court's permission. Okay, so moving on to rules that actually get a little bit harder, we're going to begin with a basic problem that applies in all derivative cases, or cases alleged to be derivative, which is that before a court can decide what procedural rules apply to the case, the court has to decide whether, in fact, the case was derivative. And, okay, we say this in the book, but it's worth saying out loud. This distinction, when you read cases like Flying Tiger or Grimes versus Donald, it can seem hard, and indeed sometimes it is, but it would be misleading to think that it always is. In most cases, it's actually quite straightforward. You will have a gut reaction about whether something is derivative or not, and your gut reaction is almost always right. So generally speaking, if a plaintiff is asserting a breach of a traditional fiduciary duty against a corporate fiduciary, and the plaintiff is a shareholder, that is almost always a derivative action. It cannot be brought in a direct manner by a shareholder plaintiff. And if the plaintiff fails to comply with procedural obligations that apply to derivative litigation, the suit is dismissible on that basis. All right. Likewise, if the plaintiff is asserting a right that belongs to them personally, like a right claiming that they've been defrauded under the common law of fraud because a fiduciary lied to them or the corporation made misleading disclosures, or if they're asserting a contract claim against the corporation or a federal securities law claim against somebody within the corporation, those rights are usually obviously direct. Okay. All right, so having said that, though, sometimes it is actually a little bit harder, and it's useful to look at cases in which it's harder because we learn some things about derivative litigation and what the courts think about it. So let's take a look at a case that in your book appears on page 664 and is called Eisenberg versus Flying Tiger. All right, so the facts of this case seem like they're quite complicated, but they're actually not so bad. Because what happened here really, even though it seems like a series of fairly complex little steps, what happened here really was quite simple. You have an operating company called Flying Tiger Incorporated. That is, it's a company that's actually engaged in some business itself with its own property, its own assets. At some point after it had been in operation for a while, Flying Tiger decided that it wanted to modify its own corporate structure so that the operating company would become a subsidiary, and that subsidiary would be owned by a holding company. And the practical effect for the shareholders of the original company would be that they would be converted into shareholders of a holding company rather than shareholders of an operating company. So that explains the transaction simply. It also turns out to explain a lot of the court's reasoning about Mr. Eisenberg's lawsuit, and that will be helpful for us later. But in the meantime, let's talk about this transaction. So you've got this operating company that's just one corporate entity, has a bunch of outside shareholders. It wants to become a holding company that owns a subsidiary. So here's how Flying Tiger did that. So first, the operating company, Flying Tiger Incorporated, created a wholly owned subsidiary called Flying Tiger Corporation. Then that subsidiary created another subsidiary that was its wholly owned subsidiary called FTL Air Freight Corporation. Then the original operating company, Flying Tiger Incorporated, merges itself into FTL Air Freight Corporation, which is the very bottom subsidiary all the way at the bottom. Now here's something important to understand. When this merger was effected, the consideration that was given to the shareholders of Flying Tiger Incorporated, the original operating company, was shares in the new subsidiary that's in the middle, Flying Tiger Corporation. That has the effect of making all the shareholders of the operating company into shareholders of the new holding company, which is Flying Tiger Corporation. So that then leaves us with this situation. Now the original shareholders, Eisenberg and all the others, are shareholders of Flying Tiger Corporation, which is now a holding company. It doesn't have any operating assets, it doesn't own any airplanes, it doesn't do any business, but it is the 100% shareholder of the new Flying Tiger entity, which is its wholly owned subsidiary. The subsidiary then changes its name so that the operating company now has the same name as the original operating company. And so this is what is up Mr. Eisenberg's craw. He doesn't like this. He doesn't want to be a shareholder in a holding company. He wants to be a shareholder in an operating company. It'll pay us to give just a little bit of thought to why that was the case. What's up this guy's butt? Why does he not want to be a shareholder in the holding company when it seems like it's kind of just the same thing? Here's the deal. It's not really the same thing because, remember, a shareholder of Flying Tiger gets to elect Flying Tiger's board of directors, and that's the extent of its rights. A shareholder of Flying Tiger Corporation doesn't have any direct role in the management of any of that holding company's subsidiaries. So at least on some formal level, Eisenberg really was denied a right to have a say in the management and the future of the airplane company, the air freight company. he doesn't any longer have any direct role in that. He doesn't elect its board of directors, and that company is pretty far removed from any concern with his preferences. So that's useful for us to understand, because that's really the gravamen of his complaint, and that goes to why his seemingly derivative action was held to be direct. Okay, so let's talk about the case itself. So before getting to anything else in the case, let's look at one distinction that the court made that is probably kind of confusing, but is useful for us to understand and is fairly important. The court says that Eisenberg brought his claim in a representative capacity. And when the court says that, it sounds like what the court is saying is that it's derivative. In other words, it's confusing because the court seems to describe his claim as derivative from the very beginning, even though the court ultimately holds that it was direct. Here's the thing. Eisenberg himself even described his claim in representative terms. In the very first paragraph of the opinion, here is a quote presumably from the complaint, in which Eisenberg represents himself as, quote, a stockholder of the Flying Tiger Line Incorporated on behalf of himself and all other stockholders of said corporation similarly situated. So that sure sounds like derivative talk, but it's not. So here's the thing to understand. Eisenberg did not bring, and he did not intend to bring the case as a derivative case. He brought it as a class action. Okay, so it is possible actually for shareholders to sue in a class action that is not derivative. And you might wonder, what difference does it make? And do we really need all this complexity and blah, blah, blah? But it does actually make a difference, because if a case is a class action, well, you still have to comply with a whole bunch of requirements under Rule 23, the ordinary requirements for class treatment. But you don't have to comply with derivative litigation requirements. And probably most importantly, you don't have to make a demand. And that's key, because the requirement to make a demand when it's not futile is really a death knell. It's extremely difficult to bring a case as a plaintiff if it's a demand required case. Okay, so when the court says throughout the opinion, we think that Eisenberg's case is representative and not derivative, what the court means is this is a non-derivative case that Eisenberg is in fact permitted to bring in a representative capacity. Okay, so the reason that, you would be forgiven for thinking, this sounds kind of like a derivative case. Because after all, Eisenberg is bringing a claim on behalf of all the shareholders, and the claim he's bringing is essentially a challenge to decisions made by the management of the company. He doesn't approve of a decision made by the board and the officers of this company to reorganize the corporation. And that sounds like the kind of claim that we often hear being asserted on a derivative basis, because it sort of sounds like a fiduciary claim. And that raises a very interesting issue. It does in fact happen that the same set of facts, the same challenge conduct can support more than one lawsuit, and the different claims that it could support, some of them may be derivative and some not. And indeed that happens often. That was held to be the case in Grimes, and the case here alleges conduct that surely could have been challenged as breaches of fiduciary duty. Perhaps not successfully, but they could have supported those claims. Okay, so this is actually very common. The same set of facts, the same sort of challenge conduct can, that was literally somebody wishing me a happy birthday. That ding was unfortunate, but actually kind of welcome, because that was an old buddy of mine. I'm 50. Anyway, so the same set of facts routinely can support more than one cause of action, and you have to think about that, and you have to think carefully about which of the causes of action the plaintiff is actually asserting. Okay, so here's the key thing. Here's some key language on page 665 in your book. In the second full paragraph on that page, the court points out that Eisenberg's beef, this is in the second sentence of that paragraph, Eisenberg's real beef is that this reorganization affected his voting rights. As the court says, he claims that the reorganization, quote, diluted his voting rights. Okay, that's really significant, because what Eisenberg is complaining of is that his rights to vote as a shareholder were changed. And here's how they were changed. He's still a shareholder in the company. He's still got the same voting rights that he had before, and the same voting rights by comparison to the other shareholders, or so it seems. The thing is, he now gets to vote in a holding company. He doesn't get to vote in the operating company in itself. He's got less control. All right? As Eisenberg points out, and the court agrees, those are rights that he holds that the corporation could never have held. A corporation doesn't have rights to vote in itself. Okay, so this is important. It turns out that shareholders do have some rights that they own personally. And one of them was asserted here, the right to vote. Another one is asserted in Grimes versus Donald, and one of the claims that Mr. Grimes raises in that case is held to be direct, even though he's a shareholder suing management decisions of corporate fiduciaries. So in discussing Eisenberg's arguments, the court has a really interesting discussion of a bunch of old New York case law. The court's talking about New York cases, of course, because this is a New York corporation. On page 666, the court starts with an interesting quote, which it actually says is not a very good rule. This is a quote from a famous corporations treatise called the Fletcher Cyclopedia. But the court says, in the Fletcher Cyclopedia, we're told that, quote, if the injury is one to plaintiffs as a stockholder and to him individually and not to the corporation, then the suit is direct. But if it's individual in nature, rather. The court says this generalization isn't very useful in our case because you could imagine how the injury was in fact also to the corporation. There was an injury, according to Eisenberg, to the structure of the corporation that hurt its operations or something like that. And the defendants actually make kind of an interesting little argument. Towards the end of that paragraph on the top of page 667, the defendants say, look, this is derivative because the thing he's complaining about is an injury caused by a change to the corporation, and you can't address his issue. You can't remedy his complaint without changing the corporation back. So inevitably, Eisenberg is complaining about something that affects the corporation and that is of concern to the corporation only. So that, I don't know. I think that's actually kind of an interesting argument, but the court isn't having it. The court says, look, if the real beef of the plaintiff's complaint is to assert a right that belongs to the plaintiff, then it is individual in nature. It is direct. If the right belongs to the corporation, then it's derivative. So the court seems to think that's a better test, and I guess I do too, it makes sense, than this question about who was injured by the thing. The question is who owns the right. And the right to vote, one's governance rights as a shareholder, belong to the shareholder. So then the court goes through this interesting series of cases in which New York courts have held claims to be direct even though they involved management decisions and the operations of the corporation and so on. So the first example is a lawsuit. This is Lazar versus Knowles Cooperative, section number 2. A lawsuit in which a shareholder is trying to force a stockholders meeting. Well, that's a claim to assert the shareholders' own voting rights. Voting rights don't belong to the corporation, they belong to the shareholders. So easy, direct. Likewise, where a shareholder, this is Horowitz versus Balaban, a little bit further down the page, where a stockholder sought to restrain the exercise of conversion rights that the corporation had granted to the president. That was also held to be direct, presumably because those conversion rights, which would give the president a whole bunch more voting shares, those would affect the voting rights of the other shareholders. That's direct because voting rights belong to shareholders. Similarly, actions to compel dissolution of a corporation are representative, which is to say they can be brought as class actions, right? Representative meaning an individual right can be asserted on a class action basis without being a derivative case. They've been held to be representative since the corporation could not possibly benefit from it, right? A corporation doesn't benefit from its own dissolution. A corporation has no right to seek its own dissolution. Only the shareholders can do that. The next case, Lennon versus Blakely, teaches that an action by preferred shareholders against the directors is not derivative because shareholders, after all, preferred shareholders can only assert their own rights. And finally, Lehrman versus Godshow Sugars discloses that an action by a stockholder complaining that a proposed recapitalization would unfairly benefit holders of another class of stock. A recapitalization means perhaps borrowing a bunch of money to buy back preferred shares or issuing a bunch of new shares of a given class of stock or something of that nature. But it benefited a group of shareholders at the expense of another group of shareholders. It affected the rights of those other shareholders, and so the court said that it was direct in nature. Okay, the last interesting thing from Eisenberg is the court's observation at the very end, that it matters if a case is brought only for injunctive relief. That is, the remedies sought matter. And this is worth thinking about for a second. If a case is brought as a derivative matter, if it's brought on a derivative basis, and the shareholder seeks to recover money damages, let's ask what happens. If the shareholder wins, the shareholder presumably has sued some fiduciary or someone else who owes something to the corporation. If the shareholder wins, that person then has to pay money. And who gets the money? Well, it's derivative, so the money goes to the corporation, not to the plaintiff. All right? If the plaintiff brings the same claim in an individual capacity, whether it's brought as a class action or not, and the plaintiff wins, well, who gets the money? Well, it's no longer derivative. In other words, the courts are treating it as a case in which the plaintiff is asserting their own personal rights. So if the plaintiff wins money damages in an individual action, the plaintiff gets the money. All right? So when somebody's seeking money damages from a corporate fiduciary, it's kind of important to ask whether it's derivative or direct, because the results are categorically different if the corporation gets the money from the fiduciary, and that's what should happen if the real injury was suffered to the corporation by breach of obligations owed to it. Okay, so the court is just saying there at the end, if the case is only injunctive, then the relief will help all the shareholders in the same way, regardless of whether we treat this as direct or not. So, as the courts often say, in close cases where it's not really clear whether a case is derivative or not, it helps to look at the remedies. And if the plaintiff is only seeking injunctive remedies, then it's a little easier to hold that it can be brought on a direct basis. Okay. So next we get another case, this time from Delaware, that also deals with this problem of distinguishing direct and derivative suits. The case is Grimes versus Donald. It appears on page 668. We're actually going to see two different pieces of Grimes versus Donald in two places in this reading assignment, because the court reached two important conclusions. The first piece of it deals, again, with this problem of distinguishing derivative suits. The facts of the case are kind of remarkable, but they're simple enough that we can just say them. So we have a corporation called DSC Communications Corp., a Delaware entity, and it engaged in an unusual employment contract with its CEO, a man named James Donald. What's remarkable about it is that Donald was given a so-called golden parachute. That is a severance payment, a big fat severance payment that he could trigger himself. And here's the remarkable part. He could trigger it if at any time in his good faith judgment there was, quote, a substantial interference by the board in his carrying out of the affairs of DSC. So that's remarkable because that's something the board literally can't do. Boards of directors cannot give away their authority to interfere in the affairs of the corporation, and indeed, quote, interfere is a weird way of describing it because it's the board's responsibility, its inalienable duty to interfere and oversee the affairs of the corporation. We've seen cases before in which courts have said contracts in which the board's power is undermined, contracts that emasculate the board, as is sometimes said, are unenforceable as a matter of public policy. So in this case, we get a shareholder plaintiff who wants to challenge this thing. He actually raises different claims against it, proving once again that the same set of facts can give rise to different causes of action. And the question in the case is whether his claim is derivative again. It gets a little bit complicated because to some extent he did actually proceed as if this was a derivative case. And you'll notice on the top of page 669 that he did in fact make a demand as is required by Rule 23.1. Okay, that gets real complicated though. It gets really hairy, and we're going to talk about later what significance that had. For now, it's important that because of actions that the board later took, it became important for Mr. Grimes to try to claim that his lawsuit was direct and not derivative. So the question for the court is, again, whether in effect he's asserting rights that belong to him or rights that belong to the corporation. And this is kind of instructive because the court says Mr. Grimes has asserted different claims, different theories of liability, as plaintiffs often do. One of them, in fact, could be described as the assertion of rights that belong to him. The other ones can't, though. The one that asserts his own rights is the so-called abdication claim. He claims that the board has improperly abdicated its role. And this is like the void for public policy argument. Grimes is saying, as an injunctive matter, a board can't do that. So this employment contract is unenforceable. Okay, so the court says that's direct, right? That doesn't have to be brought as a derivative case. And that, again, is because Grimes is asserting rights that essentially belong to him. The right to hold this employment contract unenforceable belongs to him because what he's saying is the board, which is his representative, the only group that he gets to elect with his voting power, and the only vehicle through which he can have influence in corporate governance, has undermined itself in a way that affects his rights differently than it affects the corporation. So the court says on that basis it's direct. This court, too, on page 669, observes that same thing, that same idea, that remedies also matter. If the only remedy is injunctive, and that is the case with Mr. Grimes's abdication claim, then it's more appropriate to treat it as a direct case. All right, so there are some think about this questions that are useful for us to talk about on page 670. Question A. Allison, a shareholder of ACO Incorporated, is concerned that the board of directors of ACO is about to issue shares of ACO at a price that is less than the price she paid. If she sues to enjoin the sale, will her suit be direct or derivative? So this could be a couple different things, and this is where it matters to think about what the cause of action actually is. My first instinct was, well, this is probably direct, because remember, if a corporation issues shares at too low a price, that can have the effect of diluting the value of the shares of the existing shareholders. Specifically, if a corporation issues shares at below fair market value at the time they're issued, that can dilute the value of the shares of the individual shareholders, and they have a cause of action to challenge it. And in that case, her claim plainly would be direct. You could think about it, though. This could also be a fiduciary duty case, because if the board just messed up and sold the shares at too low a price, well, that hurts the corporation, and that could be a breach of their fiduciary duty of care. In that case, the claim would plainly be derivative. It does probably matter that her claim only seeks injunctive relief, but it depends on how the claim is pled in the complaint. Question B. Boris, a shareholder of BCO Incorporated, which was formed for the limited purpose of acting as a holding company. He learns from that the board of directors of BCO has resolved to take the corporation in a new direction, operating a fleet of taco trucks. If he sues to enjoin the change of business, will his suit be direct or derivative? Again, it depends. It depends on what his claim is. It's probably derivative, because it seems like he's probably asserting an ultra vires claim. We're told that the corporation is formed to act as a holding company, which implies that perhaps there's a limitation in its charter prohibiting it from owning an operating company. But ultra vires claims are derivative. They're brought for injury to the corporation. It's possible that he might bring a so-called vote dilution claim of the kind that was raised in Eisenberg, though. Remember, in Eisenberg, you got a shareholder who participated in an operating company that was turned into a holding company, and that diluted his voting rights. So you could have a claim like that too. Just depends on what claim the plaintiff is asserting and who owns the underlying right. All right, finally, question C. Selena was a shareholder in the cleverly named Seco Incorporated. Following approval by the board of directors and the shareholder of Seco, the corporation was merged into DCO. Selena, who voted against the merger, believes that the shareholders were not adequately informed either of how sloppy the board's approval procedure was, or the fact that DCO shares they would receive have less value than the Seco shares they give up. If Selena sues the former board of Seco, is her action direct or derivative? Again, it depends. If the claim is that the company was sold at too low a price, well, that's an injury to the company, and it's a breach of the director's fiduciary duties, especially if she challenges the board's failure to adequately inform themselves. That sounds like a Van Gorkum case, sounds like a duty of care claim. Notice, though, that she claims that that she wasn't adequately informed. In other words, she claims that there was a failure of disclosure. So that could give rise to a couple of different theories of liability. For example, there may be a common law fraud claim. There may be a claim under the federal securities laws. There could be claims she could assert as a shareholder based on rights that she personally owns, based on the failure to properly inform her, and those could be direct. Okay? All right, well, moving on. There's one other topic we're going to talk about today, and it's a big one. We're not going to cover it all, but we're going to introduce it. And that is the obligation of all shareholders who seek to act as derivative plaintiffs to make demand on their managements before bringing suit. Okay, so it's useful to just step back for a second and think about what a demand would look like in the real world. What is it? What actually happens? What does a shareholder do? What does the corporation do in response? And the answer is it could be a lot of things. Okay, a lot of things could constitute demand. So in the ordinary case, particularly where the plaintiff is represented by counsel, a demand is a fairly formal affair. Typically, it will be made in a letter form or in written form in some way. In the writing will contain specific statements about what was done that the plaintiff objects to. So typically the plaintiff will specify certain specific acts of particular fiduciaries of the corporation, claim that they were inappropriate, and ask that appropriate steps be taken. That writing will typically be delivered to the board, because the board is the ultimate decision-making authority in the company. It doesn't technically have to be delivered to the board, though. The demand can be delivered to any person who has appropriate authority. You might ask, well, who has appropriate authority? And the answer is anyone who has sufficient authority as an agent of the corporation to file a lawsuit. So that likely includes the CEO, perhaps the general counsel. Lawsuits against a fiduciary of the corporation are pretty significant decisions, though, so authority probably rests only in the board and very high-ranking officers. Okay, so what happens then, you might think? And the answer is the board typically will, the board's going to respond. You might wonder, can the board just ignore the demand and go on with business as usual? And the answer is no. A case we're going to talk about a little bit later, the second half of Grimes versus Donald, specifically mentions that the board can't just ignore a demand. Specifically on page 675, Grimes versus Donald tells us this in the first paragraph under the header, wrongful refusal distinguished from excusal. On that page, the court says, in no event may a corporation assume a position of neutrality and take no position in response to the demand. That will constitute what we'll learn in a second is called a wrongful refusal. And the plaintiff will be entitled then to go sue. So the board is going to have to take some action. So the response, though, typically will just be, it'll be in writing in most cases, and the board won't actually write it. Nominally, the response will come from the board in all likelihood. But, the first thing they're going to do with the demand is send it to the general counsel for a lawyer's opinion. The general counsel will recommend doing nothing. That is, recommend a response that says, we're not going to do what you want, Mr. Plaintiff. So the board then will return a letter to the plaintiff shareholder by way of counsel saying, thank you for your interest in the corporation. Thanks for your wonderful suggestions. We hereby have decided to take no action at this time. Okay, so plaintiff can do a few different things then, and a few different rules can follow depending on what happens. But that's basically how it works. Demand is relatively formal, but it really only constitutes the sending of some letter or some writing to the board of directors, which is then responded to in kind. Now, actually, the steps that follow start to get pretty complicated. They get pretty hairy. And so I want us to just look at a diagram that I prepared that shows what happens then. So we're going to look at derivative litigation in terms of a timeline. So the first thing that happens is the shareholder discovers that something's wrong, and that could be all kinds of things. It could be conduct of a fiduciary, it could be some transaction or contract that the company has entered into. Then the shareholder either makes a demand or doesn't, and the management makes its reply. Now, since the management's reply will usually be to decline to take any action, the shareholder plaintiff, if they're serious, will go to court. So what happens next depends on whether the plaintiff made a demand or not. If the plaintiff did make a demand and the management declined, the plaintiff will plead what we call wrongful refusal, and we'll talk about that in Grimes versus Donald. And the wrongful refusal challenges the board's conduct after the demand was made. But if the plaintiff didn't make a demand, if it wants to go to court, it then has to plead what we call futility, and we'll learn about that also in Grimes versus Donald and from a fundamental Delaware case called Aronson versus Lewis. So the plaintiff at that point has to plead with particularity that it didn't make demand because demand would have been futile. So the board at that point is almost always going to move to dismiss. Corporation managements tend to disfavor derivative litigation very strongly, and they essentially always attempt to dismiss. The management's motion for dismiss can assert a number of things. Again, it depends in part on whether the plaintiff made a demand or not. If the plaintiff did make a demand, the board will allege that its decision not to take action was not wrongful, and therefore that the plaintiff has no right to proceed on a derivative basis. If the plaintiff didn't make a demand, the board will certainly assert that demand was not futile, and that the plaintiff should have made a demand, and the failure to do so requires dismissal. Even if neither of those things work, though, the board can attempt to dismiss on other grounds, including any of the procedural requirements surrounding derivative litigation, including whether the plaintiff actually held a share at the time that the case was filed. You'll notice from some of these cases that there are other miscellaneous requirements that are required only of derivative plaintiffs. For example, in Eisenberg versus Flying Tiger, what the company was actually attempting to dismiss on was the plaintiff's failure to post a bond to secure against the company's costs of litigation. That was just required by statute in New York. Okay, so there can be a whole bunch of little requirements like that, and boards will generally attempt to assert all those claims as well. And so at this point, it's finally time for the court to rule on all this pretrial motion practice. And how the court rules, again, depends on whether the plaintiff made a demand or not. But the legal standards actually turn out to be relatively similar. If the plaintiff did make a demand, the court's question will depend on whether there was a wrongful refusal. If the plaintiff didn't make a demand, the question will depend on whether there was futility. So the court will rule one way or the other, and we're going to learn about all those legal standards in later cases. The court could also rule at this point on any of the other miscellaneous procedural rules that apply to derivative litigation. If the court does dismiss the case, though, the case goes to trial, and the shareholder plaintiff is in charge. Okay, so that's a big picture view of the timeline of derivative litigation under the Delaware rules. The first of the major things that happens in that timeline is that the plaintiff has to determine whether or not to make a demand. And to figure out how plaintiffs make that decision, we first have to look at a case that isn't reprinted in your book in full, but it's described a little bit on page 672. The case is really important. It states the basic test for demand futility. So if a plaintiff who wants to wants to decide whether or not to make demand, has to decide whether they can plausibly plead. And remember, they have to make the pleading with particularity without access to discovery. So they have to decide whether they can really pull that off, and therefore take the risk of avoiding demand. Again, if they fail to make demand, they go right to court, and they fail adequately to plead futility, then the case gets dismissed and they're out. Here's another thing that's actually pretty important to understand about this, though. As is mentioned in the Grimes case, the excerpt from Grimes that we're going to read in a second, the Delaware courts have said that a special legal consequence that's pretty unfavorable to plaintiffs happens if they do in fact make a demand. If the plaintiff voluntarily makes a demand, the plaintiff is held to have conceded that demand is required. Okay, so in other words, if you make a demand, if you just write a letter to the board and say, here's what I think is a problem, you have conceded as a matter of law that demand would not have been futile. Okay, that is really significant because if you then attempt to go to court, the standard under for allegations that the board's refusal to act on your demand, the board's wrongful refusal. The standard for proving that refusal was wrongful is very disfavorable. It's generally business judgment rule. And that follows, it gets really complicated, but that follows because of a case that we're going to talk about in the next lecture called Zapata versus Maldonado. Okay, but if you concede demand, you're essentially saying that the board can thereafter dismiss your lawsuit so long as their decision to dismiss was consistent with the business judgment rule. Okay, so you file your complaint, you say, I made a demand, whatever. You've conceded as a matter of law that demand was not futile. The board will then attempt to dismiss. The only hope you have is that you can say that the board's decision to dismiss itself, not the underlying conduct, the decision to dismiss was not consistent with the business judgment rule. And that's going to be very, very difficult unless you can claim that there was a failure, that either that the board members were conflicted or that there was a failure to reasonably inform themselves about the decision. The motion will be granted. Okay, so this decision whether to make demand or not is significant. Generally speaking, if you're serious about suing, you can't make a demand because the motion will then be dismissed. Okay, so let's talk about Aronson. Facts are a little peculiar, so let's just take a look at the a drawing of it and the couple of rules that follow from it. So let's take a look. So Mr. Lewis was a shareholder in a company called Myers Parking Systems Incorporated. He brought a suit that was alleged various fiduciary claims against the management of that company, including its board and officers. One of them in particular was a board member named Leo Fink. He also happened to be a dominant shareholder, had nearly a majority of the shares. And Lewis alleged that Fink dominated the remainder of the management of the company. And in practical terms, that probably is true. Majority shareholders do tend to call the shots. But in particular, Lewis believed that Fink had coerced the remainder of the management of the corporation into giving him unduly preferable employment terms and various loans and so on. So Lewis alleged fiduciary claims against the management of the corporation. So Lewis did not make a demand, and the company, the defendants attempted to dismiss, alleging that the case was derivative, which was not contested, and that Lewis had failed to make demand. The Supreme Court of Delaware, for the first time, laid out a very clear test for determining whether demand was futile, as Lewis claimed that it was. Lewis himself actually made some allegations that were relatively feeble. They surely didn't meet the standard of pleading with particularity, and none of them would be sufficient to demonstrate futility. In particular, Lewis pointed out that each of the board members, the only people who actually have ultimate authority in the corporation to make decisions, each of them was a defendant in the case, and he claimed it would be futile to ask them to sue themselves. Moreover, he alleged that the board members were dominated by Fink, but his only allegations to support that were that the board members were appointed by Fink and were beholden to him for their positions. Okay, so the Delaware court wasn't going to be satisfied by that. Those allegations were much too plain, much too general, and instead the court gave us a legal formulation for what the test of futility would be. And this is now the test in Delaware. It's also very prominently used in other jurisdictions. So let's figure out what those elements are. There are two of them, and they are as follows. First, the plaintiff must plead particularized facts that tend to raise a reasonable doubt of the following. Now, before I move on, let me point out one thing. The Supreme Court in Aronson used this weird phrase, raise a reasonable doubt. That's caused a lot of confusion. It's language borrowed from the criminal law that doesn't seem to fit, seems to imply a very high pleading standard that apparently wasn't what was intended. Grimes actually explains this a little better. That is, the Delaware Supreme Court in the later Grimes decision said, look, in Aronson, all we really meant by this was that the plaintiff has to plead particularized facts that create a reasonable belief. If you want to see that for yourself, it's in footnote 3 in the excerpt of the Grimes opinion that appears on page 675. Okay, so the plaintiff has to plead particularized facts tending to create a reasonable belief, if you like, of the following two things. First, concerning the independence of the board or other appropriate decision maker. And second, concerning the underlying conduct, and specifically whether that underlying conduct would enjoy the protection of the business judgment rule. So let me elaborate on that just a little bit. The court is saying under element 2 that the plaintiff can demonstrate futility if they can show that the underlying conduct, that is the challenge conduct itself, wouldn't be protected by the business judgment rule. So in the Aronson case itself, for example, if the plaintiff could allege particularized facts showing that the defendants in that case were unlikely to enjoy business judgment rule protection for having given Mr. Fink the benefit of lavish employment contracts, then that would be futility. Bear in mind that's a fairly difficult demonstration to show. Assuming that Aronson fails on the first element and fails to show that there's a reasonable belief that the board lacked independence, that the board members were conflicted or were dominated by Mr. Fink, then it's going to be fairly hard for him to for Lewis to demonstrate that their decisions were so bad that they violated the business judgment rule. Basically, he would have to show that the board members failed to reasonably inform themselves, or that they had some explicit admission, some explicit demonstration that they made the decision for some reason other than the best interest of the corporation, and that's going to be pretty hard. Okay, so let's last thing we'll say about Aronson is just to pause briefly and talk about why the court didn't buy Mr. Lewis's specific allegations of futility. First of all courts say it's not sufficient merely to claim that the board were all named as defendants, because that would be a great big loophole. It would be too easy for plaintiffs to plead futility because they would just always name all the board members. Second, Lewis made no real detailed allegations concerning domination. His other allegation of futility was that the board was dominated by Mr. Fink, but all he really said was that Fink had a bunch of shares and he effectively elected the whole board. The court says that's not going to be futility. That would demonstrate futility whenever there's a controlling shareholder. And anyway, it just isn't the case, according to the court, that directors are in fact dominated simply because somebody can have influence over their election. Okay, so that brings us to the excerpt from the Grimes case itself that appears on page 673 in the book. We already talked about the facts. There's not too much to say about this excerpt either, now that we've covered Aronson and we've talked a little bit about the derivative litigation timeline. Let's just remind ourselves what this excerpt of Grimes adds. Remember that in the case, Mr. Grimes actually filed his demand. He made a demand, and so there's no question of futility or anything like that. The problem is, remember, even after you've made demand, if the board makes a motion to dismiss, you could go to court, and Grimes did, and try to assert that there was something wrong with the board's refusal. And that's essentially what the court is talking about in the case. Now, okay, here's where it gets complicated. And here's where it's difficult to squeeze all these cases in together, because it's hard to talk about one case without making reference to the others. What's really going on behind the scenes in Grimes versus Donald is the court's effort to decide how another case applies to what Mr. Grimes has done. And that other case is called Zapata versus Maldonado. We're going to talk about that next time. But basically, Zapata versus Maldonado said, in any derivative litigation case, whether demand was made or not, whether demand is fuel or not, the board can nevertheless always seek to dismiss the case if it likes. Okay, so even if a plaintiff gets in the door, even if they make demand or they refuse to make demand and attempt to plead futility, the board can always make the effort to dismiss anyway, simply because in its view, it's not in the best interest of the corporation to proceed. All right, remember, the courts are sympathetic to that, and they make that alternative available to corporations because the policy underlying all these rules is, again, the policy of the business judgment rule. So even if demand was not made, even if a plaintiff can make a plausible demonstration of futility, the corporation can still seek to dismiss. Okay, and that is kind of what's going on here. Grimes made his demand. It was rejected. He went to court anyway, and the corporation is attempting to dismiss. All right, well, under Zapata versus Maldonado, the court said, look, ordinarily, when a corporation attempts to dismiss a derivative lawsuit asserting its own rights, the only question that will be asked is whether the board's decision itself, that is the decision to dismiss, not the underlying challenged conduct, but the decision to dismiss. Sorry about that insane dog. He only has 3 legs and his brain is not far behind. If ordinarily the motion to dismiss will be granted so long as the board's decision to dismiss itself would be protected by the business judgment rule, meaning it's very difficult for a plaintiff to avoid dismissal when the corporation attempts to dismiss unless the plaintiff has particularized facts showing that the board did not properly inform itself. Okay, but Zapata said unless demand was excused, because demand would have been futile. In other words, unless under Aronson the board was conflicted or the underlying transaction, the challenged conduct, wouldn't be protected by the business judgment rule. Basically, Zapata is saying, look, if things are so chaotically, grossly bad within the management of this company that we're willing to waive demand on the view that demand would be futile, if that's the case, we won't grant the board's motion to dismiss just because the motion itself was made consistently with the business judgment rule. In addition, the Chancery Court is also to examine whether in its own independent judgment dismissal is in the best interest of the corporation. Okay, so Zapata is the background rule behind Grimes. I know this isn't going to make a lot of sense. It's a lot to get your head around. It'll make a little more sense when we talk about Zapata. Okay, but just to summarize, Zapata said, if demand is futile, we'll give the plaintiff a fighting chance because we'll allow the plaintiff to convince the Chancery Court that dismissal is not in the best interest of the corporation, even if the board complied with its business judgment rule duties in seeking the motion to dismiss. So that's a good thing, if you can show that demand was futile. Okay, that is why Mr. Grimes is saying, look, I made demand, and now I'm facing this motion to dismiss from the board. But demand was futile. Look at the facts of this case, Your Honor. Demand was futile. It'd be crazy. I made demand, but it would be futile. Therefore, you should dismiss consistently with the rule under Aronson that says if demand was futile, the court should make an independent judgment about whether dismissal is in the best interest of the corporation. All right? That's a lot to get your head around. But that's where this part of the Grimes versus Donald case comes in, because the Supreme Court said, no. You made a demand, therefore you've conceded as a matter of law that demand was required. Therefore, the only rule that can apply in this case is that the first step of Zapata, that's the only rule that can apply, meaning the board's motion to dismiss will be granted so long as it made that motion consistently with its own duties under the business judgment rule. Okay? That's Grimes versus Donald. All right, so this lecture is almost over. There's just a couple more things to talk about. Let's look at, think about this question on page 677. We got 2 of them. Question D. The court in Grimes refers to the loss of 1 arrow from the plaintiff's quiver. The court said, look, if you make demand and it's denied, that's merely 1 arrow in your quiver. You have other alternatives to try to get relief. Is there ever more than 1 arrow in the quiver at one time? Okay, so here's the answer. Strictly speaking, there's not. The plaintiff only has 1 arrow in their quiver. And that is because the court's decision on the board's motion to dismiss merely depends on whether the plaintiff made demand or not. Let's take a look at the timeline just one more time. As we saw before, once we're moving towards the right-hand side of the timeline, after the management has made its motion to dismiss, there is a question for the court. Should it grant the motion? And it's really the same inquiry either way, depending on whether the plaintiff made a demand or not. But it's largely the same legal inquiry. The question is whether the board's motion was appropriate, whether this board is an appropriate management body to leave this decision with. If the plaintiff made demand, but it was denied, well, let's start with the other one first, the other possibility first, because it makes a little more sense. If the plaintiff failed to make a demand and has pled futility, then we have that question under Zapata versus Maldonado. If demand was required, well, then the motion will be granted so long as it was consistent with the business judgment rule. The plaintiff's only hope is if they can demonstrate futility, in which case the Chancery Court will use its independent business judgment to determine whether the case should be dismissed. If demand was required, though, then the board can dismiss. If the plaintiff did make a demand, on the other hand, it's really the same inquiry. The motion will be granted so long as it was made consistently with the board's business judgment rule duties. But notice that at this point, the plaintiff can no longer challenge the independence of the board, and that's because of the decision in Grimes versus Donald. Grimes said, if you have made demand, then you have conceded that demand is required. And remember, if demand is required, under Aronson, we know that the board is not lacking in independence. The board is, in fact, independent of any domination and doesn't have a conflict of interest, because otherwise demand would have been futile. Okay? So, in other words, if you make demand, you are conceding that the case is dismissible under the basic first prong of Zapata versus Maldonado, which is that the motion should be granted so long as it's consistent with the board's business judgment rule duties. Okay, so turning to think about this question E on page 677, how is the test that will be applied to tell if demand is excused any different from the one that is applied to tell if refusal was wrongful? And it's really the same answer as what we just talked about. Remember, if you've not made demand, the only question is whether demand was futile. But to demonstrate that demand is futile, you can in fact assert that the board lacks independence, because the two-step inquiry of futility under Aronson asks us, was the board independent? And was the underlying transaction protected by the business judgment rule? But if you've made demand, then Grimes says you have conceded that demand was required, and therefore you've conceded that the board was in fact independent and was fully competent to make this decision. Okay? So there is a significant difference. Even though the legal query is the same for the court basically either way, regardless of whether demand was made or not, there is that one critical difference. You don't have the opportunity, if you've made demand, to question the independence of the board and attempt to show that demand would have been futile. Okay, so that leaves only one last thing, and it's not very important. On the bottom of page 677, there is this nice innovation in the Model Business Corporation Act, which takes a somewhat different approach to the demand requirement. In Model Act jurisdictions, there is no futility doctrine. You simply have to make demand no matter what. Every derivative plaintiff always has to make demand. That decision was made just to avoid the uncertainty of all these cases and the legal complexity. Okay, so that's it. That was another long lecture. We made it through. There's more coming, but we'll get there, I swear. Thanks, everybody, for hanging in there with me. Again, I'm looking forward to seeing you all at office hours. I'm looking forward to hearing from you and hearing what I can do better, what you don't like about these things, where things are working and where they're not. I promise, I swear to God, I will bake you guys some cookies or some scones or something sometime soon. Hang in there.